So far we've done a basic introduction to what equity is all about, and we've spent a little bit of time talking about the history, the historical development of equity, the Court of Chancery, and the fusion that then takes place with the Judicature Acts. This lesson is going to give you a bit of an insight into how some of the basic principles of equity work and some of the basic ideas that are encapsulated in what are known as the maxims of equity. So again, this is introductory content for the SQE specification, and essentially what we have to be very clear about is that the actual substance of equity and equitable ideas derive out of some of these basic maxims and principles. The Court of Chancery developed over many centuries a distinct jurisdictional element of the law called equity, and one of the guiding principles behind this jurisdiction is the fact that there are a number of maxims which are designed specifically to offer some overarching guidance to judges when it comes to the administration of equitable jurisdiction. Now, these can be instilled and essentially elucidated or distilled, should I say, into a number of maxims, many of which are still applied to the law to this day. And these maxims are just quite helpful ways of understanding what these basic principles are associated with. Now, I'm not going to go through every single individual maxim of equity. There are quite a few. There might even be some that are listed here that aren't listed here, should I say, that need to be included as well. But these are what some of the maxims of equity say. We say that equity will not suffer a wrong to be without a remedy. Equity is equality. Delay defeats equity. He who seeks equity must do equity. He who comes to equity must do so with clean hands, the clean hands doctrine. Equity acts in personam. Equity will not perfect an imperfect gift. We'll get to that one in a future lesson. Equity follows the law. Equity regards as done that which ought to be done. So those are some of the maxims of equity, some of which are particularly easy to understand. So things like delay defeats equity, or the idea that equity is equality, or equity follows the law, or even equity acting in persona. We'll get to what that means in a second. But fundamentally then, you can essentially adjust and apply some of these principles to basic rulings, and just like where the Court of Chancery operated to sort of smooth off and round off some of the more rough and hard edges of the common law, these basic principles of equity do exactly the same thing. So let's have a look at some of these principles. Let's have a look at what some of these principles actually say. Well, the first one, this idea that equity follows the law, is a maxim that simply tells us that unless there is some reason to not do so, equity will follow the rules of the common law. Hence the phrase, equity follows the law. It means that essentially, unless there is some reason to abandon a particular rule of the common law, equity will not contradict said rule of the common law. Equity will follow what the law has in fact said. Instead, it can be said that equity harmonizes itself within the common law. Just like the ruling in Dudley and Dudley that we looked at a couple of lessons ago, equity does not destroy the law, nor does it create the law. It simply bolsters the law itself. It simply harmonizes with the law. It simply supports the way in which the common law is applied. Similarly, he who seeks equity must do equity. This simply means that if an individual is looking to seek some kind of relief, and they are looking to do so from the principles of equity, they must themselves act in a way which is fair and equitable towards their opposing party. If you're seeking equity, you must do yourself equity. Now, a good example of this, an illustration, is the case of Chappell and Times newspapers from 1975. This was a case where it was illustrated that if an individual seeks to get an injunction for the specific performance of a contractual obligation, which was the sort of facts of this case, then that individual must also be willing to fulfill on their own obligations. So if you want to seek an equitable injunction for the performance of a contractual obligation, essentially you want to force the person who you have contracted with to fulfill on their obligations, then and you want to use equity to essentially enforce that basic rule through an injunction, then you have to also yourself be willing to and be in fulfillment of your own obligations, because otherwise you can't exactly force somebody through equity to do something that you are not yourself prepared to do. So you must also do equity if you are seeking it. This is a very interesting one, which I don't think I mentioned on the Maxims list, which is that where equities are equal, the first in time will prevail. This maxim relates to situations where there might be two conflicting claims in equity, where both have some kind of merit in their own right. Well, the maxim that is developed here gives recourse for judges and for courts to essentially apply the rule correctly where these situations exist. What happens where there are maxims of equity, or situations where two claims in equity are both brought and both have merit and are both brought in their own right? Well, in these circumstances, as the maxim itself suggests, the person who makes their claim first will be the one that has priority over the other. The first in time prevails. And then a final useful illustration on the maxims of equity. Equity acts in personam. The very idea behind equity as a concept is this understanding that it acts in personam. It means that a person, it looks to the person in each and in every individual case. This is representative in the types of remedies which are often issued in equity, so things like an injunction or a search order, for example. These are illustrative of this idea of acting and applying to each individual type of case.